Improper brokerage commissions, obviously getting paid if you're inactive or expired. That's being paid for illegal brokerage activities. Remember, if you go inactive or expired, you must cease and desist. Can you be paid while you're inactive or expired for things you did while you were current and active, so long as you did not do illegal brokerage? Yeah, that's okay. The other thing too, provisional brokers can't be paid by anybody but other than their broker in charge. And then remember, while a full broker can be paid directly, legally speaking, even a full broker, if affiliated with a firm, all monies are going to go through the firm first before they go to the brokers. But if you are a full broker, sole proprietor, and you send out a referral, can you get paid that referral fee directly? Yes, you don't have a firm. It's going to come to you directly. If you're a full broker, sole proprietor, and you help an unsolicited buyer and that transaction closes, can you be paid your buyer agency commission directly? Yes. All that's okay. We talked about this one. Remember, North Carolina specific, shopping of offers is prohibited. That is disclosing material terms of an offer. More specifically, it's prohibited unless you have permission from the person whose offer it is. Okay, so be very careful. Can we say you can never disclose material terms of an offer in North Carolina? No, never is too strong, but it's highly unlikely that it's going to happen because you would need the offeror's permission, not the seller's, and the likelihood of that is slim to none. And it says, so if you buy a house that you know has a private cemetery that's not easily noticeable, the buyer client tells you that they don't want to be near a cemetery, which is now a material fact, the buyer's agent would now be at fault for willful misrepresentation. Yeah, they told you that they didn't want a cemetery or be near a cemetery, and you let them buy a house where you knew it had a cemetery. That would absolutely be well, I guess it depends on the context of the question. If you knew and you didn't tell them, that'd be a willful omission. If you knew and you told them there was no cemetery, that'd be a willful misrepresentation. So it depends on the context or the verbiage of the question, but you would absolutely be in trouble. And then, of course, arguably speaking, a cemetery being on the property is a material fact, right? That is something that somebody would absolutely need to know. So while haunted is not, cemetery being on the property is.
Yeah, so in that question, that agent knew and what I was trying to get at. So he knew that there was a private cemetery that might have been a couple of 100 years old. That wasn't very noticeable to the actual, client himself.
Yeah. So he'd be in trouble. Yeah.
Gotcha. Thank you.
Remember, we talked about the settlement statement. You have an obligation to review it for accuracy of all items of which you are aware. Not all items, okay? So if you're a buyer's agent, you're looking at buyer stuff. If you're a listing agent, you're looking at seller stuff. And even still, you're not going to know everything, right? The listing agent's not going to know the loan payoff. The buyer's agent may or may not know loan cost for their buyer client, because that's just something between them and the lender. Contracts and closings in North Carolina. Now, remember, we looked at the contracts piece in from a national point of view. You got to understand that there's a lot of contract questions. Okay, a lot. Basic contract law questions more so on the national, a little bit on the state, but then, of course, the very specific contracts as well on the state. What you got, Robert?
Just since we dipped into contracts, I had this question in my notes. Destruction of property came up twice. So, destruction of property does not necessarily end an agency agreement, but it does end a contract.
Okay, let's get more specific here, because this is where you got to be careful. It depends. So, in agency contracts, destruction of the property would kill a property-specific agency contract. Which ones are property-specific? Listing agreements and property management agreements. Because we have been hired to manage a specific property, or we've been hired to list a specific property. So if the property burns to the ground, that would kill a listing agreement. If the property burns down, it would kill a property management agreement. But it wouldn't kill a buyer agency agreement because they're not property-specific. So Robert, you say, I want to find a residential resale in Wake County. And we find one. I have a buyer agency agreement with you. We find one, we get under contract, and that house burns down. Well, there's a chance your sales contract may die, but you and I can just go find you another house to buy because that was not the specific house that we agreed upon. It just so happened to fit the bill. So buyer agency agreements do not die with destruction of the property, but property specific ones do. So now let's answer the other side. There you go, Nathan. So under basic contract law, destruction of the property does kill a sales contract. Why? Because of impossibility of performance. The promises cannot be fulfilled. You promised to give me this house. I promised to give you this money. If it burns down, you cannot give me that house exactly as it was. And you definitely can't give it to me in the time frame you said, because now we got to go through insurance. We got to rebuild the house. And so that's going to kill a sales contract in general. But the word of caution that Nathan remembers, when we're dealing with this in general, that would be true. But if we're on North Carolina section, and when I say using the standard form 2T and a contract or a home gets caught on fire, what happens to it? The contract does not automatically die on the 2T. Because if you recall, there's this provision that states that the property is not in the same or better condition, reasonable wear and tear accepted as on the time of this offer. The buyer has two options. They can elect to move forward and be entitled to the burned down house and the insurance money if they want to. Or they can elect to terminate and they get all their monies back. It's their call. And so for that reason, if we're talking about that specific contract, don't say it dies automatically. It doesn't. But it could die if the buyer wanted it to.
Perfect. Thank you.
Yeah, for sure. A couple other things with the contracts, and this is true of, really any state, but parole evidence rule states that only what's in the contract is part of the contract, okay? And so if you get a test question that says, we're under contract using the standard form 2T or not, right, under contract in general, and then buyer and seller agree that the seller is going to leave their washer and dryer, and then they don't, right? And if it's just a verbal agreement, is there any recourse? No, it's not in the contract. Only what's in the contract is part of the contract. Okay, oral agreements mean nothing. Okay, let me rephrase that. Don't get confused under basic contract law questions. There are plenty of oral contracts that are enforceable, but in North Carolina, the oral agreement would mean nothing because in North Carolina, contracts for the sale of real property have to be in writing. And our statute of fraud says anything that's part of the contract has to be in the contract. So don't automatically state from a basic contract law point of view that oral agreements don't mean anything. There are plenty that are enforceable. There are plenty of implied agreements that are enforceable. But if we're talking about contract for the sale of real property and something was an oral agreement outside of the written contract, it would mean nothing. It would mean nothing. Other piece contracts to be interpreted as a whole. If you got a lot of amendments, if you got a lot of addenda, a lot of different pieces, you have to look at it as a whole thing. You can't just look at, parts of it. You either have to accept or reject the whole thing too. Talked about that one. Sources, standards. Remember the contracts that we use as standardized forms in North Carolina, not North Carolina Real Estate Commission. They come from North Carolina Association of Realtors in conjunction with the North Carolina Bar Association. Nathan says, I noticed a lot of the answers for verbal agreements on the practice. The word may comes up plenty of times. May. And so you got to be very careful because, there are plenty of things that may happen. And that's a very different answer than must, right? So those absolutes are very dangerous, but may is also very dangerous because, if it could happen, that's arguably a correct answer. May be enforceable, may not be enforceable, may. So you got to pick the best answer there. Folks, let me give you just a couple of the big things, okay? This, I'm telling you, I have heard, there's a lot on my test, but I've heard even more that there is some on the state licensing exam. So when we're talking about the 2T, you've got to know there are some big points that you're going to be very tested on. So listen to me here. First things first. When is due diligence due per the standard form 2T?
Effective date?
Yeah, you gotta use the right word. The effective date, which is the day it becomes a contract, and who does it go to?
The seller.
The seller. Okay. So due diligence fee is due on the effective date, and it goes to the seller. When is earnest money due per the 2T?
It's a really good question.
That is a really good question. There you go, Lisa. Within 5 days of the effective date, yet again. And who does the earnest money go to?
Attorney.
Typically an attorney, but there you go, Lisa. The escrow agent doesn't have to be an attorney. The escrow agent can be an attorney. It could be a brokerage firm, whoever we name as the escrow agent. It's just whoever's going to hold this money in a trust account. So the other piece, while we're talking about earnest money and due diligence, it's very testable, is how these show up on a settlement statement or a closing disclosure. So how does due diligence show up on a closing disclosure?
The seller debit, buyer credit.
There you go. It is a double entry item because as long as the buyer goes to closing, they get their due diligence back. So we take it back from the seller and we give it to the buyer. So seller debit, buyer credit for due diligence. What about earnest money? How does earnest money show up on the settlement statement? There you go, Lisa. Just a buyer credit. The seller never touched it. It was sitting there as liquidated damages the seller would have been entitled to if the buyer breached, but if they went to closing, they didn't breach. So it is a single entry buyer credit. The escrow agent says, we've been holding this for you. Here you go. And just give it back to them. So single entry buyer credit. Now, a couple other big things, okay? What happens if the due diligence and or earnest money is not delivered on their due dates? What can happen in the 2T?
Doesn't the seller need to give them a banking day? It was one banking day to comply with the payment.
Written notice. They got to give them written notice of their failure to do it, and then one banking day after that written notice to remediate it and immediately available funds. And what happens if they do not fix it within one banking day after written notice?
You have the right to terminate.
The seller has the right to terminate, and even more than that, can go after the buyer in small claims court for the due diligence and earnest money plus court costs, and they will win. They absolutely will win because it's spelled out plain as day. What you got, Jonathan?
So I had a question. There was another question that was similar to this one, kind of like what we were just talking about, where if you get the offer to purchase and contract, but there's no due diligence and earnest money given, like is the contract void? Or it was kind of along those lines. So I wanted to make sure I didn't mix that up because you have a banking day if you give them written notice, you know.
So let's talk about this. A couple things. First and foremost, understand that a contract can absolutely be valid without due diligence and without earnest money. Both can be zero. Why? Contracts have to have consideration. Consideration is the purchase price. Due diligence and earnest money are just negotiation tools. Now, even on top of that, remember what I cautioned y'all on under basic contract law. If you don't deliver them, we still have a contract, but you're arguably going to be in breach. And when you're in breach, that gives a non-breaching party the right to terminate. So buyer gets under contract, doesn't deliver the due diligence, doesn't deliver the earnest money. Do we still have a contract? Yes. It would be dependent on the seller giving that written notice and then terminating to end it. Breaches never kill contracts. Somebody has to do an action to kill it. So is it still a contract even if they don't deliver it? Yes. But could the seller potentially get out of it and be entitled to both those monies? Also, yes. Got to be careful with that.
So at that point in time, would the contract, would it be voidable? Would it be valid? Like, because I remember there was a question along those lines too.
So this is another one of those areas where I gotta tell you to be very, very cautious because I think that there's a lot of testing providers, and who knows? I don't think that I wrote questions this way, but here's the dangerous thing. Okay. Some testing resources will tell you that a contract is voidable because this party is breaching. That's legally not the best answer because voidable means we're going to take back the contract and pretend it didn't exist. That's not what happens when somebody's in breach. What's in breach is you're entitled to remedies. So you have the right to terminate. That doesn't make it voidable. Voidable is like, let's take it back and let's pretend there was no contract. Pretending there's no contract means you're not entitled to remedies. You just want to be returned to where you were. So voidable is not the best answer, but could it be the best answer on that particular question? Yes. It's possible just because of the way that some of these stupid test questions are written. But voidable is not the best answer because, like I said, you have the right to terminate as the non-breaching party and you're entitled to remedies. That's the best answer. But you're not voiding it because voiding it means you didn't have a contract at all, right? To take it back is not the same thing. Yeah.
Okay. Yeah, I may be going too far down the rabbit hole.
Well, listen, every question is too far down the rabbit hole. It's not you.
Right.
It's the concepts. It's the concept.
It's true. There's a couple that got me. So just to make sure I fully understand it. So at that point, if you don't get your due diligence and earnest money, could the seller just say, I don't want to deal with this and walk away, or do they have to give them the written notice within and give them 1 day to sort it out?
Yeah. So that's exactly right. I mean, if you have the test question where they've not delivered it and it's a North Carolina specific question, the seller can't terminate until they go through those channels, right? They have to do the written notice, give them that 1 banking day, and then they would legally have the right to terminate. Otherwise, is the buyer sitting in breach? Potentially, but they could fix it at any point until the seller does those things. Seller doesn't have the legal right to terminate until they do those things.
Okay, that makes perfect sense. Thank you for clarifying.
Yep. What you got, Karan?
So since earnest money and due diligence are negotiating tools, is it then correct to say that you can have a valid contract without either of those?
Absolutely. So always answer the test question that way. Do you have to have due diligence and or earnest money? No. And that's why multiple times in the contract it says, including their zero, is fine. Because it's the purchase price that's a consideration. You do have to have consideration. Due diligence and earnest money are not consideration. Yeah. So we talked about due diligence. We talked about earnest money. Let's talk about the due diligence date. When does the due diligence date run through?
In the agreed upon terms.
In the agreed upon terms. So we're going to pick a date. Buyer and seller are going to mutually agree on a date. But then more specifically, when we pick a date, when does it run through?
It's not 5 p.m. that day.
It is 5 p.m. that day.
Okay.
5 p.m. And it is a no wiggle room concept. What do we call that when there's no wiggle room on that?
Must be done.
Time is of the essence.
There you go. Time is of the essence is the legal term. It must be done, but time is of the essence is the legal term. And so what this means is if you terminate as a buyer at 4:59 p.m. on that date, you legally terminated during your due diligence period. And if you terminate during your due diligence period, you're entitled to what money's back as a buyer?
Both.
No.
Earnest money only.
Earnest money only. You paid the due diligence to have the right to terminate. You don't get that back. Got to be very careful, folks. I'm telling you right now, there are so many test questions on my test that you're going to take this weekend with that, right? What monies you're going to get back. If you're a buyer terminating during due diligence, you get earnest money back only. Due diligence is gone, but you paid to have that right to terminate. That's why you paid it. But if you're a buyer and you terminate at 5:01 p.m. after your due diligence date, right? Now you get back what? Nothing. Because you've lost your due diligence and now your earnest money is liquidated damages that goes to the seller for your breach. You're not breaching when you terminate during due diligence because you paid for the right to terminate. But you are breaching when you've terminated after your due diligence, because basically what happens is after your due diligence period hits, our contract upgrades to bilateral. You've now promised to buy and they still promise to sell. So now it's a breach if you terminate after due diligence. So you got to know when you get the monies back. Of course, some of the other big things. Go ahead, Karan, what you got?
So it's easy to remember that due diligence is never coming back, basically.
Never coming back if you terminate. But remember, there was 4 times that you could get it back, okay? So obviously you get it back if you go to closing, right? Buyer credit, seller debit. The other times that you would get it back if you don't go to closing, seller breach of contract. Obviously, if you terminate, you could get it back. Under the protections, this is another very testable thing, I promise it is. Under the protections of the Residential Property Disclosure Act, remind me, if I give you a test question, it says, Karan put in an offer on 123 Main Street with a 2T, and he has not received the property disclosure or the MOG. What can Quran do?
I can back out of the contract.
For how
Which
long?
means
3 days.
3 days. Remember, 3 days from the effective date if you haven't gotten these disclosures, or 3 days from the date they can prove that you've received them, whichever occurs first. That is a test question I promise you're going to see. Quran gets under contract with the standard form 2T, has not received their property disclosures. On day 2, he decides to terminate. Which of the following is true? Quran will get both his due diligence and his earnest money back under the protections of the Residential Property Disclosure Act. That's a test question. I promise it is. So there's number 2. So seller breach, protections under the Residential Property Disclosure Act. If you terminate because the property is not in the same or better condition, reasonable wear and tear accepted, we just talked about, right? If it burns down. And then the last one is the newest one, which I don't think has made it on the test yet, but just in case, the last one deals with governmental compliance issues. So for example, if there's unpermitted space and it's not disclosed to the buyer before they get under contract, and then they find out while they're under contract, what it states is, if the seller can elect to fix the issue and get it up to governmental compliance, and then there's no harm, no foul. But if they refuse to fix the issue, the buyer has the right to terminate and get all their money back yet again. So that is a new one, which is now 4. It sucks because for years I thought, well, there's only 3 times you get your due diligence back. And then last year there's 4 times. And then I used to have to say the additional provisions, addendum does 6 very specific things. And I'm like, it does 7. So I have to change my numbers over years of teaching. So, once upon a time, the offer to purchase and contract when I got in the business was 13 pages. It's 17 pages now. In 9 years, we've moved from 13 pages to 17 pages. Isn't this fun? What you got, Ekta?
Just piggybacking on this scenario, there was a question on the practice test that someone bought the house and right next day they discovered the roof was leaking, and during the whole period, the contract period, they never received the repo or MOG disclosure. What are buyers' options now?
So they got under contract. They hadn't received the MOG or the RPODs and figured out that there was a roof leak.
No, they closed on property,
Oh, they closed on the property.
and after closing the property, they figured out there is a big leak in the roof, and they never received these disclosure during the entire process.
They have no recourse. So the only protections from not receiving the disclosures is that 3-day protection period. When you close on the property, you've invalidated your rights. You no longer have any protection. And remember, the seller, even if they had given you the RPODs and the MOG, could have said no representation. And the only thing they're not allowed to do is cover it up. So if the question is, buyer didn't get them, buyer didn't find this roof leak, figures it out after they close, they have no recourse. If there was a different question that said, seller provided the RPODs, stated there was no issue with the roof, buyer closed on the property, found out after that there was an issue with the roof, and the sellers tried to cover it up, what's their recourse? They can sue them for misrepresentation or fraud because they've got a statement where they lied. They said no issue. If they could prove that the seller knew there was an issue, they can go after them. And the other thing too, you're going to get the test question that says seller knows about their roof leak, agent knows about the roof leak, seller says no representation, agent fails to disclose it, who's in trouble? Only the agent, because the seller has every right to say no representation. But the agent has to legally disclose all reasonably ascertainable material facts they knew. So conversely, you could have a question that says seller knows and lies on the RPOD and says, no, there's no issue. Agent fails to disclose who's in trouble. Both. Because if you lie on the property disclosure, you are in trouble as a seller. But if you say no representation, you're not, as long as you didn't try to cover it up. So let's talk about some more 2T things. Let me see if this will trigger some different things for me here, because I don't want to go on the most important. Remember, from a definition point of view, settlement is the meeting where all parties go to sign their respective documents, but closing is recordation of the deed. Of course, big things that have to be outlined both at the listing agreement and in the contract. What's real property, what's personal property, what stays, what goes. We only need to talk about things in the contract if we want them to do the opposite of what they're supposed to do. So if we're okay with the seller's couch leaving with the seller, we don't name it in the contract. But if the buyer wants it, we would have to name it in the contract and ask for it. Okay, same thing with fixtures. We don't need to name fixtures in the contract if we want them to stay, because that's what they're supposed to do. But if the seller wants to take them with them, we need to name them as an exclusion, right? We need to specifically name them if we want them to do the opposite. Remember, there are no contingencies automatically in any contract, including the 2T. And a contingency is the get out of jail free card. If I can't do this, I don't want to do that. Most common things you see, financing contingencies, like if I can't get an interest rate of better than 6%, then I'm not going to buy your house. Or, a contingent sale. If I can't sell my house, I can't buy your house, and I don't want to be penalized. There is no automatic contingencies, but I told you some of the contract questions you could get. Such and such is under contract, but states are not going to buy their house if they can't sell theirs. What type of contract is this? Executory with contingencies. Because there is a contract, it's not fulfilled, so it's executory. And because there's this contingencies, it'd be both. Obviously, part of due diligence would be making sure you can get adequate insurance, double checking documents, making sure you can get utilities, making sure you can get your loan, making sure your appraisal comes back good. All of these things would be part of your due diligence process. Some of the other really big things, obviously, these are not big things, but seller obligations. Folks, you could have a test question, okay? Seller legally has to be able to convey legal marketable title to the buyer. And they also, per the 2T, right, North Carolina specific right now, have to convey title by way of a general warranty deed. Remember, we talked about the different tiers. That is the best one to get. Remember, all deeds transfer title. But the general warranty deed has the most protections, right? The most guarantees. So best one for the grantee, highest form of liability for the grantor is this general warranty deed, right? The covenant of season, covenants against encumbrances, covenant of further insurance forever, covenant of quiet enjoyment, and covenant of warranty forever. As far back as it goes, forever and ever, amen. Okay, a lot of things there. Of course, being aware of certain costs, both from a sales point of view, but a closing disclosure point of view as well. Deed prep, seller expense, because that's preparing the deed to transfer. So deed prep is a seller debit. Excise tax, seller debit. Taxes are prorated between the parties, so it could be either or depending on taxes. Rents are prorated between the parties, could be either or depending on the parties. Attorney fees, buyer debit, because that's going to be their title search and the paperwork they're doing for their lender. Title insurance, both the lender's policy and the borrower's policy are buyer debits. Commissions, typically a seller debit. Purchase price, double entry, right? Purchase price is a buyer debit and a seller credit. Loan amount for the buyer is a buyer credit, doesn't affect the seller. Seller's loan payoff is a seller debit, doesn't affect the buyer. So keeping those costs straight, knowing that those are things. Of course, one of the other big testable things, folks, well, actually, let me throw another thing in the mix. If I told you that Chris was under contract to buy a brand new condominium, and he had changed his mind and he wanted to switch and buy something else like a townhouse, what would you tell me that Chris's rights were?
Yeah, 7 days to withdraw.
7 days. So if I said Chris changed his mind and wants to terminate on day 6 and it's a new condominium, would you agree that Chris can terminate and get his money back? Yes. If it's a resale condominium, no. But if it's a new construction condominium, so these are the kind of questions I'm going to throw at you on the state licensing exam. They're going to be in depth, right? I mean, it's not going to say how many days do you have for a new condominium. It's not going to say that. It's going to say Chris is under contract to purchase a new construction condominium and on day 6 changes his mind and wants to buy a townhouse instead. Which of the following is true? Do you see how that works? I'm giving you scenarios to test you on concepts. It's mean and hateful, I know, but that's the way we test it because that's the way they test it. Okay, so I'll just keep that in mind. You may have questions on being able to terminate under the Residential Property Disclosure Act. You may have questions on getting to terminate under the new construction condominiums, protection. You may have questions on, the property was destroyed. Can you terminate? There's all kinds of things that can come into the mix here. What about if everybody can't close on time? Okay, we have the closing date of today, April 12th. What happens if somebody cannot close on April 12th, which is the settlement date we agreed upon?
they could agree to push it back.
They could, so that's an option. Could all parties agree to amend the settlement date? Sure, they could, but what else?
You get an extra 1 week.
7 days.
2 weeks.
7 days. 7 days. Just 1 week. Yeah. So there is this automatic delay in settlement of 7 days built in. So basically what we're saying is if as long as everybody's going towards, Hector says just too many scenarios in state practice test, very confusing. Yes. It's also that way on the actual test. So careful. If we say that it was supposed to close on April 12th and we say everybody's working towards it, but one party can't close, they're not in breach yet. They have 7 days from the proposed settlement date to get to closing without being in breach. But on day 8, now that delaying party would be in breach of contract. But remember, breaches do not automatically kill contracts. It would give the non-breaching party the right to potentially terminate, though. So just be very careful with that. And then also remember, too, if to y'all's point, if they amend the settlement date, if all parties agree to move it out 5 days, 6 days, 7 days, that 7 days goes out with it. Because if you change the closing date, 7 days runs from the new closing date now as well. What you got, Karan?
So it says settlement / closing. So the 7 day is after settlement date, or
well, understand,
or either.
they're actually the same day, right? Typically. The only reason why it's saying settlement / closing is just because some people do use those as synonyms. But remember, closing is when we go record the deed. We can't record the deed until settlement has happened. So what we're stating is they're not going to be able to go to this day where they sign all the documents because the documents aren't ready. So that's all we mean.
Okay.
Yeah.
So basically 7 days after settlement, if we're purist with the definitions of settlement and closing.
Yeah, whatever the scheduled settlement, really. You're not going. So, if it was scheduled for the 12th and we're not ready, we're not showing up on the 12th. So that's the day it was scheduled. So what we're stating is 7 days from the scheduled date, you're not in breach of contract. But you're not going to sign anything if everything's not done and ready. So we're going to move that date out. But if we don't change it on the contract, you are only protected for 7 days from the initially agreed upon date.
Got it. And are there any typical reasons why settlements happen but closing doesn't happen, i.e. like recordation doesn't happen?
Yeah, so just so we're on the same page, that could happen. So if we all go to closing at 4 o'clock in the afternoon and the attorneys get caught up and or the system's down for e-recording, there's a chance that everybody went and signed on Thursday afternoon, but they couldn't record the deed because the Register of Deeds office shut down at 5 o'clock, which means the buyer wouldn't legally own the home until next morning when they open back up and they recorded it. That does happen. Yeah. So we are almost to the end of this. Let me answer the question in the chat. Exclusive right to sell listing agreement. Most common, there is one authorized agent / agency representing the seller. What does the CY mean here? It just means it could be an individual agent or agency. So remember, we've talked about this. When you're dealing with brokerage relationships, the default is the agent is the firm, which is sometimes referred to as an agency, right? Real estate agency or real estate brokerage, real estate firm, which is an entity. But could there be a sole proprietor hired? They would just be an agent and not an agency. It's just, kind of a contextual thing where could be talking about a whole firm, could be talking about an individual person, could be talking about a sole proprietorship. That's all it means there. But they've only hired the one, whatever it is. One sole proprietor, one firm, one brokerage, whatever you want to call it. That's all. So we've talked about a lot of the things within the 2T. You got to be very careful. Some of the other questions that come into play, and let's see what they rank this as like a level here. I don't know to what extent you really need all these, but just be aware that the addenda, plural of the word addendum in North Carolina, those are add-ons that become part of the contract. So they're part of initial offer formation or creation, right? We add on an FHA/VA financing addendum, an additional provisions addendum, a backup contract addendum. And then when you sign the offer and you communicate it back, that becomes part of the contract. Amendments are changes to an already executory contract, right? An already in place contract. And so most of these are pretty self-explanatory and not very testable, I would argue. Backup contract addendums have a tendency to show up on the test. And so remember, I told you if the home's already under contract and you want it to be in this position of like secondary, where like if that deal falls through, you're buying it, that would be a backup contract. The other ones that I told you I absolutely think will be on the test is those buyer possession before closing and seller possession after closings. Why are those so important? Why are those so testable? Insurance coverage. Because remember, whoever is the quote unquote tenant in those scenarios would need renter's insurance. And then the other person would need landlord or homeowner's insurance. So just make sure that you're aware of those. Sales contract procedures. That goes back to a lot of the things. Obviously, no shopping of offers, delivery of instruments, all those things come into place there. Remember how offers are handled. Counter offers kills the original offer. The roles switch. Everything in between. So making sure you keep those straight. In North Carolina, our settlement agent is typically an attorney. There is this thing where non-attorney settlement agents can do certain things, meaning like they're paralegal or a staff person. They can actually instruct people where to sign and collect monies, but a non-attorney settlement agent would not be allowed to do title searches or anything like that. Due diligence process, we've talked about. Oh, this stuff's pretty straightforward. Settlement meeting, closing, we've talked about. Financing and settlement. Here's where we get into some of the financing questions. And so let's just talk about some of the vocab with the financing. Of course, principal and interest payments are also referred to as debt service. So if we say debt service, it's your principal and interest. That is how you're amortizing your loan. Amortization is the repayment of your loan. Remember, we said there are 3 different types of amortization. There is a fully amortized loan, which means whenever your term is up, you have paid your balance down to 0. There is a partially amortized loan, which means you have been making payments that reduces your principal balance, but when your time is up, there's still a balance left, which results in what we call a balloon payment. If you got to pay a lump sum at the end, that's called a balloon payment. There is also what we call straight term or interest only loans, which means you're paying only enough to cover the interest. And then those would typically end with a balloon payment as well. Those are much more common in things like developers who are going to be selling these lots for very large sums of money, and they expect to have the lump sums to pay it off, and they want to keep their carrying costs low. So that's why they're only paying interest only. Of course, pity payment, principal, interest, taxes, and insurance. That's part of what we call a budget loan. When you're escrowing those taxes and insurance. Equity is the difference between what you could sell for and what you owe. And that's part of net worth equity. The 3 ways equity increases: appreciation, pay down of debt service, and then of course capital improvements. Usury is charging more or greater interest rates than limits set by law. And so there are usury laws that limit the amount that you can charge, and to charge more than those limits would be usury. Discount points. Remember, it's going to be a buyer debit on a closing disclosure, and a discount point costs 1% of a loan amount. Loan stuff can only be charged on loan amount. Don't ever use purchase price for loan stuff. Okay. So 1% of the loan amount is how much a discount point costs. But remember, it reduces the interest rate by 1/8% for the buyer. And so we always teach this as discount points are prepaid interest that just goes straight to the bank. It's a fat stack of cash, and it increases the lender's yield and reduces the borrower's interest rate. Why does it increase their yield? They would have normally taken months to get this interest, but instead you just gave them a fat sum at closing. Not really a good idea if you plan on refinancing or selling in a short period of time. Some of these other things, remember the mortgage and the deed of trust. Those are the security instruments in their respective states. North Carolina, we're a title theory state. We utilize a deed of trust. There are 3 parties to the deed of trust instrument. Who are they?
Your beneficiary, your trustor, your trustee.
Yeah, what's the other name for trustor? So the trustor is not going to be as testable on the deed of trust for the sake. So we've got the beneficiary, we've got the trustee, and we've got the grantor, who is also the borrower. Those are the more legally or technically appropriate names. So, when we're dealing with the trustor is the person who creates the trust. The trustee is the person who oversees it for the benefit of the beneficiary. But more often we call them, right, the borrower, aka the grantor, because they are transferring that naked legal title over to the trustee, and that trustee is holding that legal title on behalf of the beneficiary, which is the bank. Who is the trustee? Typically, an attorney who works on behalf of the bank. And so because they're already holding this legal title, this utilizes what type of foreclosure in title theory states like North Carolina?
Non-judicial.
Yeah, non-judicial, also called a power of sale foreclosure. Okay, we're already holding it's very easy to foreclose. So remember, in lien theory states, which North Carolina is not, they use mortgages as their security instrument. And how many parties are in this mortgage instrument? Deuces. Who are they?
Mortgagor and mortgagee.
Mortgagor or mortgagee. Who is who?
The person that took out the loan is the mortgagor, and the bank is the mortgagee.
There you go. Mortgagee is never me. Mortgagee is the bank, and the mortgagor is the borrower, because we give the bank the mortgage. Okay, they give us a loan, and we also give them a promissory note, and we make these payments. Remember the two documents: promissory note is the evidence of the debt and the promise to pay it back, and then the mortgage and deed of trust in their respective states is the security instrument, which pledges the home as collateral for the debt. So if you default, they can go after it. What you got, Robert?
Oh wow, the video too. Just to go over that one more time, the three parties in a title theory closing, the beneficiary, trustee, and grantor. What were the other terms? I know the other term for the grantor is the borrower.
Yep. You don't really need... The beneficiary is the bank, and then the trustee is typically an attorney that works on behalf of the bank, but they're really not going to call them anything else other than trustee and beneficiary.
Okay, and then, yeah, grantor, borrower being you.
Yep, grantor or borrower being you. You're the one. And remember, don't get confused, because when you buy the house, there's a deed from seller to you, where the seller's the grantor, you're the grantee. But the reason why you're called the grantor is because you turn around and you are signing over that naked legal title to the trustee. So you are referred to as the borrower, aka the grantor, because you're transferring that title to the trustee. And be careful, because on the test, there will be questions like, in a foreclosure auction, if there's more money than what the bank is owed, who's going to get the money in excess of what the bank's owed? Well, that's going to be the grantor, the borrower, right? Because if they're foreclosing against you and there's more money than the bank's owed, you're entitled to get it back. Does that make sense? But it's not going to say the buyer. It's not going to say, because what's going to be happening is this foreclosure is part of this deed of trust relationship. So when they say the grantor, that's the person they're foreclosing upon. Does that make sense? Yeah. So, promissory note, lien theory, title theory, foreclosure, hypothecation. Remember, hypothecation is the act of pledging the home as collateral for the debt. Of course, remember the clauses that are very commonly tested. Acceleration clause, what does that do?
You've not paid, so now you got to pay everything now.
Yeah, there you go. It accelerates the maturity of the debt because of a default. And it could be that you didn't pay as a default, but you could be in default for not maintaining the property. You could be in default for doing a major repair without authorization. So there's other things that can make you in default. But you've defaulted, and so you had 30 years, but now because you screwed up, everything is due and payable immediately. That's the acceleration piece. Prepayment penalty, by the way, acceleration clauses exist in every single loan, every single one. Prepayment penalty clause would be where they penalize you or charge you, fees if you pay off the loan early. I told you most mortgages do not have prepayment penalty clauses, or at least not long-term ones. Sometimes conventional loans have them only in like the first year or two. But prepayment penalty clauses are prohibited on all government loans. So FHA and VA, it is prohibited to have a prepayment penalty clause. Same thing with the alienation clause, also called the due on sale clause. Government-backed loans are prohibited from having an alienation clause or due on sale clause. So remember, due on sale means if you're transferring ownership, alienation is to remove yourself from the ownership. That means somebody has to get their own loan. Yours has to be paid off. So when an alienation clause exists, it means the loan is not assumable. Assumable meaning somebody could take it over. They can't do that if there is an alienation clause. It would have to be paid off and they'd have to get their own loan. Of course, we just talked about the foreclosure pieces here. The other thing, just to remind you when we're talking about the deeds, if we're transferring ownership by way of a foreclosure in a title theory state, it's a trustee's deed. If we're transferring ownership by way of a foreclosure in a judicial foreclosure or lien theory state, it's a sheriff's deed. Of course, obligations, signatures of spouses, right to foreclose, all that stuff's outlined in these documents. Yeah, cash sale. I told you there's this nuance to cash sale. Don't get so caught up on it. That's not really going to throw you off on the test. Cash sale just means the previous balance is being paid off. So even though most people get a paid down payment in cash and then borrow money, they still call that a cash sale. It just means that the other one's being paid off. There is cash. It's just coming from the bank. But there's, of course, somebody purchasing with all cash, which is also a cash sale. But that's just a confusing nuance there. Purchase subject to seller's existing mortgage. I warned you about that. It's a level 1, which means you're probably not going to see it, but I did talk about the dangers because what's happening is you're not transferring the mortgage or you're not transferring the loan. Nobody's assuming it. You're just paying it on behalf of the other person, but then you're transferring title, which is probably going to end up being loan fraud in most instances. What you got, Nathan?
Here's a question I'm just trying to remember. Now, it was ECOA that wasn't involved in cash sales? Or...
Yeah, because ECOA, it just deals with lending. But also, TRID does not deal with cash sales either, meaning RESPA. RESPA nor ECOA care about cash sales because they only deal with borrowing money. So if we're talking about cash sales, meaning the weird nuance one, where you're putting a down payment and borrowing money, ECOA would apply and RESPA would apply because you're borrowing some money. But if you're actually paying cash, like you got $600,000 in the bank and you're buying a house with $600,000 in cash, RESPA does not apply, ECOA does not apply because there's no lending. Yep. Good question. Remember too, RESPA does not apply for commercial purchases either. So if you're purchasing a bed and breakfast, a hotel, a grocery store, a gaming store, anything that's a commercial purchase, RESPA does not apply. So once again, greater than 4 units, RESPA doesn't care. Even if you're borrowing money. Businesses, they don't care. Short sales, remember we talked about this a little bit. Short on funds to satisfy all liens would be a material fact in North Carolina. Can't do it without permission from the bank, right? You got to call and ask permission to be able to do this. Not the same thing as a foreclosure. Sometimes they are happening in tandem though. Of course, we talked about conventional mortgage loans, obviously private loans. The lender bears all the risks. There's no government backing. They set the interest rates. They're the ones lending the money. And so what was the magic number? If you don't put down a down payment of at least what, you're going to need what we call private mortgage insurance. 20%. And it's called private mortgage insurance because it is through a private mortgage insurance company because these are private loans. But when we get into FHA loans, those are not private mortgage insurance. They're just called mortgage insurance because they're through the Federal Housing Administration, right? Government subsidized, so it's not private. But 20% is the magic number. And remember the same cool thing about conventional. If you get to the point where you have at least 20% equity in your home, then your private mortgage insurance can drop off. Sometimes you have to do a formal request. Sometimes you have to have a new appraisal, but it can drop off. FHA insured loans are backed by the government. Remember, the Federal Housing Administration, not Fair Housing, Federal Housing Administration is not the one lending the money. They are not the ones setting the rates. They are merely providing the insurance to help protect the lender's risk. And it's not covering the whole loan. It's covering the spread between the 3.5% down payment and the 20% the bank would have liked to have seen. So if they foreclose on you, that's going to help cover the spread if they don't get enough money because you had so little equity in the house. But the FHA is not lending the money. And buyers still have to qualify. A little more lax on credit approvals, right? You can have a slightly lower credit score. You can have slightly higher debt to income ratios for FHA loans. But this insurance is coming from the Federal Housing Administration. And I told you, this is the one, the 203B we mentioned briefly, is the most common program for residential properties. There are rehabilitation loans and agricultural and condominium ones for FHA, but those aren't really going to be on your test in North Carolina. See, it says it's only necessary to be aware that other FHA programs exist. You don't have to know what they are. What you got, Jonathan?
The question, just from a testability perspective, there was a question on the practice final about like which specific section of the FHA loan applies to like a residential purchase. Are we going to see that on your actual test, or can you tell us?
I don't recall that being a specific question on my test, but so that's what I'm saying. The only one that you would really need to know, and the answer to your question, is a 203B. That's going to be the FHA loan that applies for residential. But as you see right here, there are ones for senior borrowers, rehabilitation, condominium purchases, special loan repayments. It's only necessary to be aware that other FHA programs exist. You don't need to know the specific numbers. But as I stated before, some of these exam prep materials, you know, they come from the publisher. I don't take them out just to be on the safe side. But are you going to see the things about like 203Ks or anything like that? No. Not on my test, and probably not on theirs either.
Okay.
Yeah.
Cool. Thank you.
Mm-hmm.